fair warning of the recording process. So welcome to topic 4 on fair use. This week we don't have a presenter, so we don't have the pressure of someone needing the discussion and to complete their assessment and so on. So we can be a bit more relaxed. Not that I don't think we're ever not relaxed, really. But I might just talk through some of the things that I think are important about this and give you the reasons why I set this as a topic, even though no one's going to be sort of writing up the actual policy this week. The other thing I should mention is I realised I left a little bit of information out of the guide for this week, and that's on transformative work. So I've put a link on transformative work into Moodle, and in the next version of the course notes, I'll make sure I integrate that more. So transformative work, again, it's unclear how much it applies to us because it's more of a US concept, but that's when you take someone's work and you transform it and use parts of that work in your work. It's not as open or free as we'd like it to be, but for instance, someone has, there's endless variations on Michelangelo's David, where people have done, David in an apron cooking, or various other versions of David. So there is scope for being able to reference other work. Not when it's done in a sort of a cheaty sort of way, but in a way that's a collaborative and transformative way. And so I've given you some sources on that, and some fairly, I think, easy to read discussion. If this is something that you're ever have the need to chase up, but at the end of the day, it's one of those. Part of the whole problem of this area is that the legal rules are very abstract, and they're things that say fair use. You go, that's fine. Fair use sounds excellent. Let's be fair. Let's use things fairly. But what does it mean in a specific circumstance? And that's where we get into trouble on that. So anyway, I've put some more resources there. I've realised it's a bit of a gap in the notes. And I think I've linked an article into the main DIGO site as well. And yeah, before, one of the other things I mentioned in the group email I sent out this afternoon was, if you're not, the 2 assignment DIGO groups are the ones you have to sign up for. It's very easy to sign up for them, but make sure you do that. If you don't know which assignment you want to do, you can always sign up for both. That's purely because the account I'm using, the educational account, only gives me one open group, and the additional groups have to be closed. So it's just a pragmatic thing. I also don't think it's a bad thing that our assessment groups are closed. We don't have time to think about it. It's probably not a bad thing that we have control over who can see what goes in there, because it gives you a little bit of protection, gives you a little bit of it's more of a private space. So, but if you're not in either of those spaces, you just need to click on the links, and there's a click request access, and then an email goes to me, and when I see the email, I grant access, and we're all good. And if you have any problems with it, just let me know, and I'll see what I can do to help. But yeah, that's going to be a more and more significant thing for us as we go, I think. And going to be more and more useful as part of the research process. Anyway, let's get back to fair use as a topic. We looked previously at that tension between ownership, monopoly in intellectual property, and community rights. And these are, part of them, it's the public domain, but it's also broader than public domain. The idea is that you shouldn't have total control over IP. And the exception that was traditionally written into the US laws was fair use. For some reason, and I've never actually found any documentation of why, the Australian legislators put in fair dealing instead of fair use. It'd be fascinating if anyone ever found out why that was done. There's some indication that it might be a more limited right, but it doesn't come up often enough, I think, for the courts to really have set a very firm precedent about the difference between the two. But it covers all those ancillary things that you can do with someone's IP that are not going to interfere with their economic rights. There's an interesting argument that that rather than IP being a property right, it probably should be a fiduciary right. That's a very kind of law nerd technical distinction. But what it means is instead of it being like a piece of property where you say, I own this and I can stop anyone else having access to it, a fiduciary right would be saying, I own, my right is to the income streams relating to this thing, and I can control the income streams. Now, that would probably be a better way of dealing with a lot of rights, because a lot of IP rights, because it would be, it would really hone in on the fact that what you want to stop people doing is making money, and you then, or using it in a way that's stopping you making money from something that you've created or owned. So, for instance, music rights. Thinking about music as intellectual property is inordinately complicated, and there's questions, all sorts of questions around, what if someone sings a song that someone else owns the IP rights of? Well, that's generally seen as fair use. But if they're singing it on stage and they're charging money for it, then it's not fair use. It should be licensed, except that people do cover versions of other people's work all the time, and that doesn't seem to be licensed, and there doesn't seem to be a problem with that unless you actually record it and put it on an album. It'd be so much simpler to be able to say that if you are using another song in a context where you are interfering with the owner's ability to make money out of it, then that's when the rights are being breached. And then we can avoid all this. Well, how is me singing a song in the shower different to someone singing it on stage? There's a question from Michael about performing covers, and I don't think the law is terribly settled on this. I think it's one of these things that once upon a time it was just considered to be completely within the scope of fair use. However, there's always someone that abuses these things, and if you were a band that performed nothing but covers, like a covers band, I think the rights owners would probably be fairly upset about that, except the covers bands have existed forever and they've always been allowed to exist. So the horse has kind of bolted on that. And
the reason I asked that question is because I went and looked up APRA and had a look at all like when you're allowed to use music, when you're supposed to pay them, that sort of thing. They even mentioned in shopping centres, when you're playing music for public entertainment or whatever, you should be paying the rights holders to listen to that song. So I think, well, even if Woolies has to pay to have music playing, which explains why it's so crappy
I heard how people Men in Woolies the other day. I was shocked because I like Monsters and Men. It's like, what's this band being played in Woolies? Sorry, go on.
No, that's okay. So I'm just really, really confused about what I suppose there's what people do, which is ignore the law and just do whatever they want. But what does the law actually say about people who are DJs in nightclubs, who Woolworths, even in retail stores where they have the radio on? I mean, is that allowed? I mean, what's the line?
When we're dealing with something that's recorded, that's when they generally come into play. So if, I was approached by was it APRA? It might have been ARIA way back when, at some point, saying they had some work for students to go around cafes and pretend to be customers and then to dob them in if they're playing CDs without them being licensed or authorised. And I told them we weren't interested in that. But there's a whole sort of network of policing, and at some point they figured out that they could try and make money out of cafes, and gyms are another one. And they send out their spies, they find people who are in breach, and then they dob them in and get them in trouble and make them pay licensing rights. So this whole area is changing, And it's taking an area that was generally kind of informal and people sort of felt, you know, what's it harming someone if I'm playing some CDs in a shop, to being seen as, you know, literally the worst thing since Nazi Germany, that we have to take all this action on and stop people doing. And I think the difference with covers and covers bands is, and forgive me if I'm wrong because they may have started attacking covers bands as well, is that because this isn't recorded, it's somehow seen as different. Now, I don't think any of those distinctions are really legally defensible. It's just the practice is changing. And again, you know, while fiduciary rights are kind of tricky, I think if we focus the idea of even if we still keep the same idea of IP law, but we just shift it towards it being a fiduciary interest, then we can probably see a sense of perspective. So if some little covers band is playing a U2 song in a local club, there's all sorts of interesting things going on in the chat window. If some covers band's playing something in a club, they're playing a U2 song, does that hurt Bono? Is someone going to not buy one of Bono's CDs or one of Bono's T-shirts because they've heard someone else do a cover version of his song? You get a sense of perspective there. However, if you have a band that do nothing but play other people's songs without permission, and they're a high-profile band, so just say you had a manufactured band, a boy band or something, and all they did was play unlicensed covers of other people's hits, then maybe that would have an impact on those people's income streams. But alternatively, if they were playing covers of, and they were acknowledging they were attributing the authors, then maybe, you know, the fact that One Direction plays the cover of some little band will actually be in the fiduciary interest of that little band, because, you know, maybe 0.5% of One Direction's fans will be interested enough to look up that band and find out more about them. So this is again where the idea of property rights starts breaking down. And as soon as you get these big lobby groups and these interest groups who are out there trying to enforce these laws, the whole lot of it gets very distorted. And yeah, I'm well behind on the window, but yeah, the transformative work argument could also be an argument. And you will see, if you've had a chance to try and look at the Copyright Act from the materials in this week, there are so many different sections that talk about fair dealing. And there are so many different sections that have, it is fair dealing to do this or it's fair dealing to do that. And they're all over the Act. It's like someone has kind of eaten the legislation and just vomited it up in different kind of random orders in some places. So scientific use and educational use is all over the place. For years, there was this informal thing where educational use was 1 chapter or 10%, and it was a rule of thumb, but it wasn't in the Act. And then they brought it into the Act, but they brought it into the Act in a really weird way as to what educational use was. So this is somewhere where you can kind of get a sense of how it works and how it's applied. But the more you think about it, the crazier it seems. And the more it's sort of the logic behind it seems to break down. And that's the area where the trolls and the bullies kind of operate in. They start pushing it back further and further and further. Now, when I studied law, which was sort of 20 years ago, IP law wasn't even an elective at undergrad level. You had to do a master's to do IP law. And it really was this kind of tiny little niche area. And various things have changed that, and the internet's one of the things that's changed that suddenly. And we're talking about fan fiction, which is what we've got to come back to on the topic now. IP law has become so mainstream and so important now. And another of the things that changed the world was sampling, because sampling went from being a kind of an underground part of the hip hop scene to something that is used in all the mega $1 million vocoded horrible songs that you hear on the radio every day. So it literally went from the point where I would kind of argue that sampling was kind of fair use because it was used in a small way. It was used in a transformative way, and it wasn't the core part of the song. To today, where basically sampling is the use of an entire melody out of a song with someone rapping or whatever over the top of it, which is not the way it was originally used. And Ice Ice Baby, I think, was the classic point at which people's attitudes changed, because they saw Vanilla Ice as not actually really transforming that original song, as basically just taking the original song and rapping over the top of it, and that was no value add. And there was all kinds of complicated stuff there about the legitimacy of hip-hop as a music form, which at the time most people didn't think it was music. And there was also all sorts of interesting racial things about, was Vanilla Ice as a white guy entitled to engage in these kinds of practices? At the same time, you had people like Jean-Michel Jarre, who would sample pygmy chants and would sample music from all around the world from people in developing nations and chuck those in his songs, and that was seen as fine. That wasn't sampling because that was not seen as actually copyright material, that you could go and you could rip anything out of Indigenous people's music and use that in a song. So weird days. And we are going to come back to 50 Shades of Grey because desperate to have some kind of modern relevance to what we're talking about here. And 50 Shades of Grey is certainly an interesting example of that. Okay, so fair use is a mess. The context of what we are talking about tonight is the policy making around fair use, and what do you do as the owner of a franchise or a set of intellectual property rights about other people using your characters and settings and materials and whatever. And that's the world of fan art, the world of fan fiction. Again, it was something that traditionally has been almost unregulated, but today things have changed in such interesting and rapid ways that suddenly these questions are being asked again. And we've got that tension again between, on the one hand, sort of the big IP bullies who are trying to stop anyone using their properties without paying money for it. On the other hand, you've got the fans who are just doing it for the love of it. And on the other hand, you've got some people who are basically pirates who are just sneaking in, trying to create pirate merchandise and use the whole fair use kind of veil as saying, oh, what we're doing is just, fan art. It's not really commercial or whatever. Again, you can see that if you see it in fiduciary terms and you see it in terms of rights to income streams, you can see it more clearly. However, the law doesn't talk about that. It just talks about the use or fair use of the property. All right. So let's get on to the weird and wonderful world of fan art and fan fiction. Again, we're also, when we're talking about fan media, a lot of the focus has traditionally been on sort of science fiction, fantasy, geekdom, fan work, but fan work around musicians is also extremely relevant here as well. So when we're talking about fan art, we're not just talking about Harry Potter or Star Trek fan fiction. We're also talking about Justin Bieber fan art, increasingly, strangely enough, and even celebrity pieces. And one of the articles I posted today talked about some guy from Jersey Shore who people are mass producing some necklace that's important for God knows what reason. I don't really care. But basically he has what I guess we'd call personality rights around his image as a celebrity, because he certainly has no creative rights, and he is trying to track down people who are basically impinging his ability to merchandise his own image as well. So oh God, we've got a very technical argument around fiduciary rights here, and I suspect I don't know enough about fiduciary rights to actually engage in that argument. So forgive me if I bow out of getting into technicalities, because equity is not my area. But I'm not saying it is not interesting, and I'm fascinated by this discussion. What Margaret's mentioned too is really the crux of the matter is the balance between pursuing and protecting your rights and alienating your fan base, which is a source of the main source of income for a lot of these people. And the problem is a lot of the legal action that has occurred has been incredibly naive, is that the right word? Non-astute in terms of the market. So here's an example. Let's go back to an example everyone probably understand. The Harry Potter novels. From the very beginning, J.K. Rowling had a fairly open attitude towards people producing derivative works. There was, people saying, particularly when only the first few books were out, when's the next book coming out? People were writing additional adventures for their children. And her attitude and her publisher's attitudes was like, hey, that's fine. Of course, she didn't understand. I don't think she knew about slash fiction. And if you don't know about slash fiction, don't Google it. Slash fiction is pornographic fiction using characters from other work. And it's a whole different world, which we will come back to, but it's a whole different crazy subset within fan work. Anyway, so she was quite happy with it. So all these websites, this was early 2000s, so early days of the internet. So all these fan sites popped up with everyone's, these they're probably awful, but, that's not really the question here. Further adventures of Harry, etc. Now, they sold the rights to make the film to Universal. Universal's lawyer, Warner, I don't want to get caught out corporate defamation here. Warner's lawyers went ballistic and basically sent takedown notices with threats of fines and litigation to everyone who owned a Harry Potter fan site. Some of whom were children, many of whom were children. And this was a PR disaster for Warner that they eventually had to try and pick themselves out of. My guessing is some idiot in the legal department convinced them that this was a good way to spend their time and to give more money to the legal department and increase their budget, because all these people around the world were stealing their ideas and stealing their IP. It produced a whole lot of bad press, these horrible, horrible letters being sent to 10-year-old children and so on. What came out of that was more of a practice that many organisations will create fair use policies where they set the limits on what they think is fair. And the slash fiction I mentioned before, the pornographic fiction, is usually in the unfair basket, particularly for things like Harry Potter. Universal were fairly quick off the bat to do one for Star Trek, because the Star Trek fan fiction was also a very big area, as you probably guess, but also one where they were troubled by the fact that their lawyers wanted to sue everyone and to close down all these websites, and this new thing called the internet was going to destroy their income streams and so on and so forth. As we mentioned before, this fan activity creates value. It adds value to the income around a property. If you can get people so excited by your work that they're producing their own work and they're publishing it in an amateur way, and they're not making any money out of it, that's not harming your IP. There's no one who says, oh, I could go and buy the last Harry Potter novel, but instead there's plenty of free stuff on the internet, I'll read that instead. That doesn't make any sense at all. So I think it was a very painful process. I think that over-enthusiastic and ambitious lawyers were a big part of the problem. The problem today, though, is coming to some sense of equilibrium, because people are starting to make money via the internet. These communities aren't small anymore; they're large, they're international. Geekdom has gone mainstream, and Marvel Comics have huge movies that normal people go and see, so it's not just this sort of small subset anymore. so where do you draw the line between someone whose use is legitimate and it's a fan thing and it's really adding value, and someone who is actually doing something which is harming your interest? Now, part of the solution to this puzzle is in trademarks, and that's a completely different area. We're talking about copyright and fair use, but I'm just flagging that it may be an aspect where you can say that someone's misusing a trademark, and you may also have a remedy under trademark law. One of the traditional problems of copyright law is it's designed to cover literal copies. It's designed to, I may have mentioned this example previously, but I'll mention it again anyway. You can always tell me I've already talked about this in the chat window if I have. When the Maltese Falcon was published, copyright would cover you making a literal copy of the Maltese Falcon, like printing the text of the Maltese Falcon again, but not the characters. So there was a whole lot of Sam Spade short stories that appeared in the pulps because at that point you couldn't, and there was a legal decision to the extent that said you can't copyright a character, because copyright is about copying. It's about copying the original text. A bit like plagiarism, I guess, where, you take an idea and you reference it and you reuse it, and that's fine. But if you actually copy something exactly, it's considered plagiarism. The law was then changed to say to deem that characters, etc., would be considered copyrightable. And this is not what the copyright law was supposed to do. This is a fundamental change in the character of what's going on. So once we said we could start copyrighting characters, things, the gloves were off. And suddenly people started being able to wanting to lock down everything. And 50 Shades of Grey, and Kip said how there are various forms of copyright in one thing. It's a fundamentally weird concept, and if you had to explain it to someone who'd never come across it before, it would be quite difficult to explain it, I think. So in terms of fan fiction, it's clear that the characters are copyright or covered by copyright, although it doesn't make a whole lot of sense if you really think about it. But it's, used as a way of regulating not so much originally fan use, but professional use. And you can kind of see why, if you did write the Maltese Falcon. I don't think Dashiell Hammett had a problem with this. I think it was his company. It was the publishers. And if you did publish something that was really popular and people just started writing endless stories and selling endless stories using the characters you created, you probably would be upset about it. But is copyright...
So just have it clear in my own head how the law's working in regards to characters. Does that mean if I, say, wrote a book and it starred Jabba the Hutt and he worked at a pub, would that be infringing upon Star Wars' copyright?
Yes, unless you were saying it was a parody or a reference or transformative or some whatever. Fortunately, George Lucas is pretty laid back about this stuff. There's a doco I refer to. Actually, maybe it is in this week. The People versus George Lucas. This is kind of a side point, but it's very interesting. It talks about how, to one extent, George Lucas is a very canny businessman and does things to exploit children and sell them Jar Jar Binks toys and things. But on the other hand, he has a very strange and sort of open attitude to intellectual property and really encourages fan communities, which I guess could also be being part of being a shrewd businessman, because probably he understands that this stuff is actually selling more of his original product. So he's actually been quite shrewd about it. But it's a fascinating piece. And it also looks at the idea of cultural property and the sense that fans believe they have a stake in cultural property, some to a rather insane extent. And they believe that the Star Wars prequel movies have actually harmed their rights or interests in some way. as people who love the original Star Wars movies, that the Star Wars prequels were so awful that they've actually caused them some kind of harm. Now, that's something that is very crazy in this context. However, if we take it in the context of traditional knowledge and Indigenous rights, they're making a very similar kind of a claim. So while I don't think there's anything in their claim that they're saying, George Lucas raped my childhood and destroyed my childhood and did these terrible things, I don't think there's really a lot in that. However, I do see that this impulse of saying that some things are culturally owned and maybe there's an argument that some things shouldn't be owned by individuals or corporations. I don't think Star Wars is one of those things, but maybe if Star Wars is your whole life, it's your belief system, it's your primary culture, then maybe this is not all that different, at least from that subjective point of view, to things that happen around Indigenous rights and traditional beliefs and culture, where people come and try and appropriate those rights and things. So that's a topic for one of the assignment topics, but I think it's an interesting question, and it's one that I'm really not on the side of the Star Wars fans. I think it would be insulting to make an argument that Star Wars should be counted in the same breath as Indigenous cultural rights. However, I think it is an interesting perspective on those rights. So, after a certain period, no one would own Star Wars because it's a film. It's like 75 years after the film, though. That's the problem. IP's been extended so far, but maybe at the 75 years from 1977, Star Wars will be considered like a religious cultural institution and it will fall into the commons. Who knows? But in terms of fan fiction, I think the really interesting thing that's happened recently is 50 Shades of Grey. Not the 50 Shades of Grey is at all interesting, but 50 Shades of Grey started out as Twilight fan fiction. And once the book deal was done, the author sent it to publishers and changed the names of the characters. When the book deal was done, she took down all existing versions of the book that were on various fan sites. But of course, the internet gets archived in various places, so people managed to dig out using Wayback Machine and other services like that. They dug out old copies of this and said, look, it's the same thing, except in this version it's Edward and whatever her name is, thingy, and in this version it's Christian Grey and the other thingy. They've literally, and I think the expression is filing the serial numbers off, they've literally just changed one character's name for another one. The question is 50 Shades of Grey a misuse, a breach of the copyright in the characters of Twilight that created from Twilight?
I mean, I haven't watched 50 Shades of Grey, but from what I can recall,
I'm not going to set it as homework.
So, I don't know. I don't know enough about the two things to actually draw parallels, but one seems to be about smut and one seems to be about vampires. So,
yeah. It's one of those weird things, because I think if you tried to publish it with the original names in it, people would be even though it's got very little to do with vampires and things, people would feel more confident before they change the names of saying that's a breach of copyright. There was actually, I'm not sure where, there was actually a legal case over it, and the judge was very horrible to Twilight and said the characters are so flimsy and insignificant they don't possess any copyright. You could actually see nothing copyrightable about the characters, and therefore there was no breach.
I'll admit I am guilty of reading the first Twilight book. I don't know why, I just felt compelled. And Judd's absolutely right. They're two-dimensional. He's just making a factual statement there.
And this is, again, this is what makes IP law so difficult, but I also think it's what makes it so fascinating, is that number one, it's that difference between legal rules and practical application. We hit everywhere in law, but it's something we can all relate to because we all, read books, watch TV shows and things as well. So I think it's, we probably have the same problems of legal definition in areas of financial law or corporate law, but that stuff is generally so remote from everyday life that we sort of, it's harder to get into it. Whereas here we can I think the metaphors are things that we're all pretty familiar with. And yeah, it does. I mean, so much of what Hollywood does and things that make a lot of money are completely derivative of other work. So at what point do you say something is taking a character? At what point does the character, of the brooding, handsome, loner outsider, to what extent is that character at all copyrightable because they appear all the time and everyone reuses them? Kids asked the question about the transforming to another media form, and that is an issue for copyright. And in fact, there was a whole lot of law reform went on in the 90s and 2000s around digitisation of work, because no one had thought about it at that point. And they said, well, what if someone scans a book and it's in a computer? Does that mean that it's something new? And we had a whole lot of changes to the Copyright Act that said, yes, it's still copyright. And if you scan a book, it's a way of copying it. And there's some very obtuse and technical amendments to the Act that probably are poorly expressed, but it's because at the time lawyers and computers didn't mix, and they were overly cautious in trying to include digital versions within copyright. One of the you get some interesting things here where the rights get split. One of the biggest shit fights in copyright, and that's the technical legal term, of all time has to be with a Winnie the Pooh fight. And that's a fight between Disney and the owners of the Winnie the Pooh radio and film rights. And what happened was that the author of Winnie the Pooh didn't think that radio rights and film rights were really worth worrying about. He thought they were insignificant at the time and gifted them to his agent and said, look, I'm only worried about the books. My children are getting the rights to proceeds to the books. But radio and TV, well, it wasn't the television that existed, and radio and film, not relevant. People don't go and see films. They don't make any money. There's no point in this. Of course, Disney has a huge marketing empire around Winnie the Pooh. And every time they do something, and I don't think it's even the agent's heirs who own the rights. He might have sold them to someone else who sold them to someone else who now owns the rights to the Winnie the Pooh TV and radio, for film and radio rights. They sue Disney every time Disney does something. So there's this incredible. I mean, if you're a lawyer in the middle of all that, it's being in clover. Really, there is so much. There's so much money to be made in that litigation, but it just goes round and round in circles. And I think it's a testimony to how much money Disney makes out of Winnie the Pooh that they're just continuing to keep pushing it because they're making so much money. It doesn't matter that they're spending a whole lot of money, and I'm saying millions of dollars on litigation, because they realise they're going to make more out of it at the end of the day. So yeah, there is a licensing agreement between their owners and Disney, and it is one of the most litigated documents in the world, I think.
So how long until it becomes open slather? Because the books of Winnie the Pooh were a very, very long time ago now. I mean, they're made free by now, I imagine.
The book rights will have been 75 years from the death of the author. Let me just let's Wikipedia A.A. Milne.
Because, I mean, Winnie the Pooh and Disney is just a reimagining of the character from the books Winnie the Pooh. So technically, if it's been, 75 years, anyone can make a Winnie the Pooh TV series if they want to.
A.A. Milne died in 1956. So, assuming that it is covered under the 75 years, it is going to come up relatively soon, as is in 2000 and actually not all that soon. I'm not a maths person. Hang on. No, it's not going to be like 2030. So there's still a good chunk of time to run on those. But again, you know, it's one of those things that, I mean, I'm no huge fan of Disney, generally speaking, as a corporation, and I think some of their corporate ethics that leave a lot to be desired. But the Winnie the Pooh property right owners are so disgraceful. Half the time you end up actually being on Disney's side when you see this stuff, because they behave in a way that's so ridiculous, and they have no real connection to the actual creator. It's that point where you're saying, it's like, oh, but we have a right to this and we have a right to that. It's like the Kookaburra song and Men at Work, and the person who owned the rights to the Kookaburra song was not the writer, was not related to the writer of the song. It was someone who picked it up at an auction somewhere. And it's very hard to, you know, get morally indignant about what was, I'm pretty sure I would have called fair use of a sample. When you're so remote from the original creator. There's also, I've referenced somewhere in here, or maybe it's later on, the documentary on remixing. It's definitely worth watching. It's an hour or so long. It isn't here. It's on page 8. Rip a Remix Manifesto. It's on YouTube, and it's put on YouTube under Creative Commons, so it's not going to be a problem watching it. You're not going to be impinging anyone's copyright. But it's a really interesting documentary. It's in the music context, but a really interesting doco on fair use and remixing rights. What about Happy Birthday? Yeah, it's the melody of Happy Birthdays in the public domain. It's the words that are a problem. This is insane, isn't it? But yeah, the Happy Birthday music is fine. But if I were to recite some of the words and upload this to YouTube, it'll probably get taken down. But it is, again, one of those ones that, and it's a ridiculous amount of money to actually license Happy Birthday. So if you actually see it in a TV show or a movie, you know that whoever made it has loaded and has paid a lot of money for it. Yeah, I think we can sing something else to the melody, that's fine. And there have been several attempts over time of people to write new words, new Happy Birthday words to fit in there. Although I think the best version has to be the Death Clock heavy metal Happy Birthday. But I won't link that one if you're not a metal fan. But yeah, I think it's not a problem with using the melody. It's just the and Brendan has just gone and complicated everything by talking about different languages. Yeah, copyright when something's translated into a different language. You can see this, as I said, right at the very beginning, I talked about copyright and all IP laws being basically a sort of a social experiment to try and fix a problem in a way which is kind of patching the existing law and borrowing a bit from here and whatever. And it was a different world. It wasn't a globalized world. It wasn't a digital economy. There wasn't a digital distribution network. When we wanted to point who the bad guys were, who were ripping people off, it was generally pretty easy to do. What we're moving now towards is a world where it's very difficult. And I probably should bring us back to Justin Bieber, because that's whose rights are really at risk here. You may know of the website Etsy, ETSY. It's a handmade market, and it was basically created because eBay became very kind of commercial, and people who were selling handmade products needed a place to sell. The thing, though, is that a lot of the things sold through Etsy are not handmade. a lot of them there's a lot of fan things that go through there, and there's generally they have fair use policies and everything else, but there generally is a lot of stuff that references other work, and it's fine. But what's started to happen is people are basically using Etsy to sell merchandise. So people are mass producing Justin Bieber merchandise, selling it through Etsy, making thousands and thousands of dollars out of it. And while I don't believe Justin Bieber needs any more money to spend on drugs or eggs to throw at his neighbour's house or whatever he does with his life, this is a serious problem, because most recording artists make most of their money out of merchandise, not out of their IP, of their songs. And if you allow people to mass produce merchandise, undercut the legitimate producers, and just sell it online through what's supposed to be a handmade site, that's a real problem. And Etsy have said they've actually had to create bots that are automated that go through and search for this stuff, because there's so much of it happening. But what was once kind of a little handmade site for people who, made a limited run of 5 or 6 of things, we now got basically pirate groups who are mass producing thousands of these things and running them through Etsy and are making a lot of money out of it. And the article I linked into Diigo also talked about, and I've blanked on the guy's name, and I don't care because I don't really care, but the guy from Jersey Shore who has some special necklace that's pertinent to his celebrity identity. And again, people have been mass producing that necklace and selling it, mass producing it overseas, where they can do it cheaply, and then selling it en masse through an Etsy store. And every time Etsy try and close it down, it moves to, they set up another store and they move it. There's this constant war going on between Etsy and basically these pirate groups. So I think that's an interesting point for us, because we're running out of time, an interesting point to leave us with, where we've got this emerging player in the field. I mean, the one is, you've got the rights owners on one side, you've got, legitimate fan artists on another who are just, here's a picture of Harry Potter I drew because I love Harry Potter and I've stuck it online. Or maybe I've produced a T-shirt with my picture, with a picture I've drawn on it, and maybe I'll sell it to, if I'm really lucky, maybe 20 or 30 people. And maybe I'll make, $100 out of the enterprise at one extreme. And then in the middle, it is always, there needs to be like a legal doctrine of the people who spoil it for everyone else. But in the middle, there's the people who spoil it for everyone else, which are the mass pirates, who are any leverage you give for fair use to the fan community are going to grab that leverage and say, oh yes, but I can use that to produce 100,000 Justin Bieber T-shirts because that's just fair use, because I'm just a fan, and my 100,000 friends that I happen to have all want to buy a copy of that T-shirt. So, bit rambly tonight. It doesn't actually get us to the point of creating a fair use policy, but I think hopefully sets out the problems around setting up a policy. How do you set up a policy which doesn't terrify 10-year-old girls and make them think their family's going to lose the farm because they've written a Harry Potter story and put it on their blog? But at the same time, how do you then stop the pirates who are going to exploit any kind of give in the system that you try to create? And then there's slash fiction, which is a completely different topic. And we could spend a lot of time talking about it, but there is that question, does something, just because it's pornographic, does that actually change the nature of it under fair use? Or is the fact that it's pornographic, the fact that we don't see that as fair use, is that something to do with our culture? And yeah, it's about part of business strategy. And the comparison I would draw is with Japan. In Japan, there's a lot of pornographic fan fiction around particularly anime characters. And it's very hard to generalize about Japanese legal system, so I don't want to try and generalize too much, but I'm never going to. It's much less regulated in Japan. It's much more likely that the Japanese will see pornographic derivative work as being fair use. Now, is that because Japan doesn't have a Puritan basis like American law? or is there something else going on? And definitely, I think in Japan, it is seen as not inconsistent with your business rights to know that some people in their own little space of the internet, their own little corner of the internet, are producing weird and crazy sort of sex fantasies with tentacles and God knows what else in it. That is not seen as inconsistent with your commercial rights. However, in the West, that's seen as inconsistent. And then if we start talking about Harry Potter / fiction, we're in a different world of ick. We're in a world where we've actually talked about the intersection between child pornography laws and copyright, and that's somewhere that's a whole big topic that we're not going to touch here, but is certainly interesting if nothing else. Okay, folks, we're running out of time. Any questions before we go? Hopefully we've got someone, or we'll soon have someone down for discussion of next week, which is Doctrine of First Sale, which is all about controlling secondary markets. So trying to stop second-hand markets or people buying and parallel importing and things like that. So if that's your thing, it might be a good workshop for you to work on. The other stuff, I might shut the recording down now before final comments.